This is Michael Popok, Legal AF, reporting on good developments for E. Jean Carroll in her civil rape and defamation case against Donald Trump, and bad developments for Donald Trump and the quote-unquote defense team, which appears to be a combination of Joe Tacopina and Alina Habba. That illustrious law firm you've never heard of Tacopina and Habba, are against Roberta Kaplan. She's on the Mount Rushmore of civil lawyers in America. That's who's representing E. Jean Carroll. And Judge Kaplan, no relation, has issued a series of rulings in the last couple of days, all to the plaintiff's advantage and all to the disadvantage of Donald Trump. Let's start from the beginning. There's been a lot of talk about the black coat dress that E. Jean Carroll claims that she saved because she was traumatized and put the dress she was wearing on the day in the department store in New York, Bergdorf Goodman, across from Trump Tower, where she says in her pleadings and in her case that Donald Trump forcibly raped her and assaulted her sexually in a dressing room at Bergdorf Goodman's after they met, knowing each other casually from around town, she being at the time a well-known gossip columnist, and Donald Trump enjoying gossip columnists writing about him. And so they knew each other. E. Jean Carroll is also married to a well-known news anchor for a local ABC affiliate at the time, when I used to watch. And so she was a known commodity, just as Donald Trump was. She kept that dress, she claims, and hung it in the back of a closet because of what happened to her. And she will testify to that at trial. DNA has been kind of moving around this case as an issue for a long time because Robbie Kaplan and her client originally reported that they had sent the black coat dress out for DNA testing, and Donald Trump's DNA may or may not have been on it. It was definitive that there was male DNA somewhere on the coat, but since they never were able to get Donald Trump's DNA to test against the coat, the DNA issue has sort of been a non-starter from the beginning. Robbie Kaplan could have moved to compel the DNA evidence. It would have been up to the judge to decide in a civil case whether he was going to compel Donald Trump to give a DNA sample, and that would have been a whole fight on that. But she never did that, and Donald Trump, despite demand by E. Jean Carroll, never voluntarily provided it, and it didn't even offer to provide it until Joe Tacopina came into the case 3 months from trial and said he would conditionally provide the DNA evidence if they were to provide the remainder of a report on DNA that they had not fully produced. So there was a whole battle over DNA. And the reporting was such that people that follow the show, Legal AF, that I co-anchor, were saying things like, she's got the DNA, it's like the blue dress, it's like Monica Lewinsky. Unfortunately, it's not, because it's inconclusive as to whose DNA is on the black coat, and Donald Trump never gave his DNA evidence. Rather than have this whole thing be litigated out in front of a jury who are going to have a bunch of head scratching in a civil case about, well, is there DNA or not, rather than focus on the testimony and the other evidence that is going to be coming through against Donald Trump, the judge, on a motion by E. Jean Carroll's lawyer, not Donald Trump, to keep out any reference to DNA, the term, the concept, the fact that for whatever reason, E. Jean Carroll, probably mistakenly so, during a deposition claimed that they had located Donald Trump's DNA on her coat dress when in fact they had not, because they didn't have the match. She probably was mistaken or misspoken. But of course, Donald Trump wanted to use that to attack E. Jean Carroll's credibility at the trial. And they were going to argue, see, she got it wrong on the DNA thing, and she never had the DNA, and let's go look at the DNA, and my client's not on there, or whatever they were going to claim. And the judge put a stop to it in a ruling this week where he said, you know what? The plaintiff's side didn't ask me to order DNA. The defense didn't volunteer the DNA. I'm not going to allow the jury to be confused by DNA. So you can't ask about it in cross-examination of Miss Carroll, Donald Trump's side, And of course, the plaintiff, who doesn't want mention of the DNA because it doesn't really cut in her direction, doesn't want to raise the issue either. Now, that doesn't mean, as we discussed last night on LegalAF in extensive fashion with my co-anchor, that the black dress is not going to be able to be talked about at trial. E. Jean Carroll is going to be able to say that she remembers what she was wearing. She was wearing a black coat dress. She kept it because she was traumatized, and they can cross-examine her about that. But when they get to does the black coat dress have Donald Trump's DNA? That's not going to be a proper question. That'll be a mistrial if Donald Trump's lawyers ask it almost immediately because it violates the court's order. So black dress in, DNA references or cross-examination out as of this week. The judge also ruled, and this is another blow to Donald Trump, that he is not going to be able to have his expert, quote unquote, expert on defamation to counter the expert that E. Jean Carroll has for her case in chief, who is prepared to testify because he has a report that she was horribly damaged reputationally, monetarily, and otherwise by Donald Trump lying about her, this is her allegations, in October of 2022, when he said she was a hoax, a fraud, he never knew her, he never touched her, she's not his type, and all sorts of other things to make it act like she's a crackpot, she's not stable, all the phrases that Donald Trump uses, including those that are misogynist against her, which ruined her reputation. That's the essence of defamation. And they have a lawyer, they have an expert who's going to testify to that at trial, to the jury on reliable evidence and analysis about how her reputation has been diminished and the monetary value of that. Donald Trump could have gotten a rebuttal expert, we call it a rebuttal expert in the business, who comes in to literally rebut line for line, opinion by opinion, the expert testimony of the plaintiff. They got an expert, or somebody they thought was an expert, but frankly, he shot himself in the foot almost immediately in cross-examination in his deposition because he said, frankly, I've never really read the report of E. Jean Carroll's expert, and so I'm really not rebutting it. Well, then what are you doing here? Experts in court are given tremendous credibility and the ability to speak and offer opinions that average and lay people are not able to offer in a court of law. They're given this special power of the ability to testify in an expert opinion that goes well beyond what a mere mortal testifying about facts can do, but they have to qualify as an expert. They have to have done reliable methodology in order to render their expert opinion. And if they don't, they're either not qualified as an expert because they don't have the background, scientific or professional, to render those opinions, or their opinions are based on Google search, which is what this quote-unquote expert for Donald Trump claimed that he did in coming up with his opinions, then they're not going to be allowed to get in front of a jury because that's the power of an expert in front of a jury, right? They can be very powerful and blow the minds of the jury. So you have to be careful, and the judge is a gatekeeper for whether experts are or not coming in. So the news flash is that Donald Trump lost his expert. He's not going to have a defamation expert. So you're just going to have E. Jean Carroll talk about the trauma of what happened to her and the impact on her reputation and her future, her political, her business fortunes. And then they're going to have an expert who has a doctorate, who did a proper methodology, who's going to testify in support of that. And then the jury would normally hear from a rebuttal expert, but that law firm of Haba and Takapina and Haba screwed it up again, and they have no expert, which I'm sure is driving Donald Trump mad that he has no ability other than through cross-examination by the lawyers to counter the damage model that's going to be put on by E. Jean Carroll. So the judge ruled that, right? No DNA, no cross-examination of E. Jean Carroll by the defense. And defense, by the way, I just took away your expert. You have no expert. You're going to have to just sit quietly and listen to the expert for E. Jean Carroll. And then you cross-examine that person, but you're not going to have your own counter-expert. And then the judge also ruled that at least one of the witnesses that the defense wanted to call, which apparently was some sort of editor or boss of E. Jean Carroll, is not going to be called as a witness because she was not disclosed timely by the law firm of Tacopina and Haba, mainly Alina Haba, because Tacopina came in so late. And so that witness, X, is off the board for Donald Trump. Then the judge made another ruling, which is also important to the case, because the case that's going to trial on April the 25th, it's 3 weeks away, where we're picking a jury in the federal court in Manhattan, is the case of a civil rape claim, which was filed right upon the passage and the signing, if you will, of the Adult Survivors Act statute by the governor of New York, giving adult survivors of sex abuse 1 year to file their case, regardless of statute of limitations. In other words, a renewed new clock to allow for those filings. And within 10 minutes, as the judge noted in a previous order, within 10 minutes of that, E. Jean Carroll filed her case. That case combined with a defamation by Donald Trump against her that happened after he was president. So in October of 2022, therefore he has no presidential immunity or claims of presidential immunity. That case we call Carroll 2, Roman numeral 2. Carroll 1, the original case, was filed when he defamed her as alleged when he was president. And there was a whole fight about presidential immunity. It bounced around between two separate courts of appeal, one federal, one territorial, one state, if you will. And that case was the original case. But the second case is the case that's cleaner in the judge's view. And that is the case that's going to trial on April 25th, civil rape, and the second defamation when he wasn't president. So the open issue is, was there a way for Donald Trump to get rid of, X out, the new defamation claim against him under some theory? So he filed a motion for partial summary judgment, which is a fancy way of saying if all the facts that you need are not in dispute, so they don't have to be resolved by a jury, and as a matter of law, you're entitled to a dismissal of a claim or a claim in your favor, the judge can rule on it, and that's called summary judgment. So he tried to argue, Trump did, that he was entitled to summary judgment to dismiss the new defamation case before trial, before it even gets to the jury, because he has another type of immunity, which is called the litigation privilege immunity, which every state has, and New York has a version of it. And in New York, it's very narrow. It's basically if you are accurately reporting the litigation that's already been filed in a courtroom, and you're just repeating accurately the progress or the things that have happened in the litigation, then you may have the privilege and immunity from being sued for defamation by simply reporting. So a lot of newspapers and media outlets use this defense because they're reporting what's on the docket, what's in the courtroom, what's been filed, what they hear if they go attend proceedings to the public. And so they have that protection. Donald Trump tried to use it by saying, well, all I was doing when I made those nasty comments about E. Jean Carroll, about her being a fraud and a hoax, and she's trying to do it because she's selling a memoir. I never met her. She's not my type. Look at her. All those comments. And then a pot shot at the judge, because this statement got made after she had already filed Carroll 1 about the judge being, a Democrat and against me, an anti-Trumper, never Trumper, all this other stuff. That was just me fairly reporting what was going on, because I mentioned the case, I mentioned the lawsuit, and the judge said, not so fast. For that privilege to apply, it's not good enough that you just mention the lawsuit. You have to accurately and reliably report what happened. And you went well beyond that, Mr. Trump. And then the judge cataloged in the actual order all the places that Donald Trump went beyond and colored outside the lines of just fairly reporting the case against him, including all the gratuitous pot shots at E. Jean Carroll, her credibility, her sexuality, her desirability, and whatever else he said. And of course, the judge said, and of course, you took a pot shot at me too, which doesn't seem to be fairly and accurately reporting what happened in the courtroom. Seems to be your opinion about something. And so you don't get the privilege for that. And the judge denied the motion for summary judgment. So once and for all, we can draw a line under this and say that in 3 weeks, in Carroll 2, a jury is going to be picked. And the two claims that are going to be before the jury are, did Donald Trump rape, sexually assault E. Jean Carroll in the dressing room of Bergdorf Goodman department store in 1995 or 1996, or did he not? If the answer to that is yes, this will be a jury verdict form. The jury finds in favor of the plaintiff. Then they go to damages. How much are you going to award, including punitive damages, which is what it sounds like, punishment damages. And then they'll draw a number. They'll put a number on that verdict form, draw a line under it, jury foreman will sign it, and they'll render a verdict. On the defamation claim, similarly, on a verdict form, it'll say, did Donald Trump defame by speaking untruths against E. Jean Carroll in October of 2022 on his social media without defense or privilege? Yes or no? If the answer to that is yes, go down to below, come up with a measure of damage, put that number in. You can add punitives if you want, draw a line under it, sign it, and the jury foreperson deliver it back to the chambers, back to the courtroom. That's what's going to happen after a 3 or 4 week trial or so in April. And we already know from prior rulings of Judge Kaplan just a week or so ago that all of his rulings about the Access Hollywood hot mic that Donald Trump was on that almost torpedoed his campaign when it got disclosed in 2016, where he out loud, thinking that no one could hear him but Billy Bush, then the Access Hollywood anchor or host, where he said he regularly sexually assaults and abuses women, that he just takes advantage of them without their consent, that he grabs them by their genitalia. That tape, that's coming in for the jury to show that he, in a sexual assault case, which is what this is, has a past conduct or behavior that this is in conformity with. So it's not a shock or surprise. And 2 women who also claimed that they were sexually assaulted and abused by him. A People magazine reporter doing a story on Donald Trump and his new marriage to Melania, who says during the Mar-a-Lago was supposed to be a puff piece in the People magazine, turned out Donald Trump pushing her up against the wall, taking advantage of her, sexually and assaulting her, and then demanding that she enter into an affair with him. She's testifying, and a woman who had the unfortunate luck to be upgraded on a plane from 1 class to 1st class and got sat next to Donald Trump, who she did not know, other than the fact that he was relatively well known, says that she was groped by Donald Trump sexually on the plane. And so she gets to testify in front of the jury. And the jury's going to hear about, this is not the first time that Donald Trump has done something like E. Jean Carroll claims that he did to her. And this is his MO. This is his personality. This is his prior history and conduct. Roll the Access Hollywood tape. E. Jean Carroll testifies, and there we have the trial, which we will cover on a podcast, the leading political and legal podcast that I co-anchor on Wednesdays and Saturdays called Legal AF on the MeidasTouch network. I do these kind of hot takes on cutting real-time legal and political issues almost every day, and you can catch them on the MeidasTouch network YouTube channel. And then we also do the Legal AF podcast, where we curate the top 5 or so stories on Wednesdays and on Saturdays at the intersection of law and politics. You can get it wherever you get your podcasts, and you can get it and watch it on the YouTube channel. And if you like what I'm doing, I'm Michael Popok. You can see me and watch me on everything social media at MS Popok. This is Michael Popok, Legal AF reporting.
Lock him up! Indictment season is upon us. Celebrate with the new Indictment Season t-shirt and v-neck exclusively at store.meidastouch.com.